Say aye. Those against say no. The ayes have it. The motion is adopted, and the House has accordingly given prior approval to the appointment of the nominee to the position of a Chief Justice.
Despite both sides agreeing to approve Justice Torkornoo's nomination, the debate leading up to this was ferocious. The minority chief whip tore into some of the Supreme Court's recent judgments.
I think she's got what it takes to be a Supreme Court judge. And I am hopeful, Mr. Speaker, that she will be a better Chief Justice than the person she's taking over from. Why do I say this, Mr. Speaker? Under the reign of the outgoing Chief Justice, the level of miscarriage of justice in this country reached a crescendo and must never be repeated. And the former Chief Justice must know when he goes home, this miscarriage of justice rests on his chest.
But first, Deputy Speaker Joseph Osei-Wusu fired back at the minority chief whip, insisting he was on a bad trajectory.
Judges know that as humans they can err, and judges always welcome criticism of their judgment. But when we are critiquing a judgment, it is expected that we will critique the judgment with law, with facts, with alternative argument.
The debate leading to the approval of the nominee centered mainly on the Judge Ikwesin case and whether or not the Supreme Court is amenable to criticism. Former Minority Leader Haruna Idrisu argued that the court is not above criticism.
The Supreme Court is not above the criticisms of the Parliament of Ghana. Indeed, in civilized jurisdictions and even in Ghana, the Supreme Court or the courts are servants of the legislature. We make the law. They are to interpret the law. That is why we are enjoined not to use language that is ambiguous. When they are interpreting the law, they are supposed to be guided by the words the legislature uses, that members of parliament uses. So nobody should think that freedom of expression is limited only in our bedrooms of Ghana. That did they construe the words before filing of nominations and before elections? Are those words synonymous? Do they mean the same? Mr. Speaker, I beg to disagree. They probably got it wrong. Before filing nominations cannot be the same thing as at the time of elections. But the legislature make the law, and therefore they ought to consider all other variables in the determination of the decisions that they make. Yesterday, Mr. Speaker, you swore in a member of parliament for Kumao. At what material time, Mr. Speaker, did you administer the oath of allegiance to him? And therefore, was the Supreme Court making a determination on allegiance to the state? And at what state was Jesse Ikwesin swearing to an oath of allegiance? Was it at the time of filing or at the time of election or when he swore in this chamber?
However, MP for Abuako South, Samuel Atachia, warned that the NDC MPs should not turn Parliament into a Supreme Court review chamber.
You know the processes of amendment, which we have even the power to initiate in this House. Mr. Speaker, I agree with you that any time we are in this chamber and then we veer into territories that are not ours, we will make some serious errors.
With the approval of Parliament now out of the way, the only thing stopping Justice Gertrude Torkornoo of becoming the new Chief Justice of the Republic is the swearing in of the Republic. But we understand that is a given, and as soon as this evening or early tomorrow, President Akufo-Addo will swear her in to become the third female Chief Justice of the Republic. And a lot of people have expressed optimism that she will be the one to turn the tides. In recent times, the Supreme Court and the judiciary have come under a barrage of criticism, particularly from the opposition NDC and elements within that faction who say that the court's judgments have not been reasoned enough in the Constitution. Reporting for JoyNews, Kwiku Asante, Parliament House, Accra.
All right, so welcome back to the AM show. We're talking about the appointment of Justice Gertrude Torkornoo as the third female Chief Justice for the Republic. Now, we've been joined on the line by the GBA General Secretary to help us delve more into, okay, so I'm told it's the PRO rather, to delve more into these issues. Well, we're also expecting to speak with Mahama Yariga, who's lawyer and MP for Central Boko Central, and Joseph Benka, former Deputy Attorney General. But let me start with you, lawyer. Now, you definitely will be dealing directly with the Chief Justice because of your profession. Your reaction on her appointment as the third female Chief Justice of the country, then we can delve into more issues. Hello, sir.
Hello, sir.
Yeah, grateful for joining us here on the AM show. First of all, your reaction on her confirmation as the Chief Justice, and then we can delve into other issues.
Yeah, good morning and good morning to your viewers. Can you hear me, sir?
Yes, please, sir.
Very well. I will start by congratulating her on her approval by Parliament as the incoming CJ. But I must also correct the fact that I think I overheard you say she's the first female Chief Justice.
No,
she's not
third.
the first.
Third.
Third, okay. Third,
Yeah.
okay. Right. So we are congratulating her on her appointment, on her approval by Parliament. I think what is left now is just a matter of court for her to be sworn in.
Okay. Now, you had the MPs there saying that there were some reforms that she had to undertake as a Chief Justice to bring back the sort of reverence that the Supreme Court or the court system had in Ghana. What do you expect her to do to try to revive, in quote, the image of the judiciary?
Thank you very much. I think that the outgone CJ, the immediate past CJ, operated a policy that the bar liked so much. He gave us a lot of access to him. We operated what we call in Ghana an open door policy. And I expect Justice Torkornoo, the incoming CJ, to do so. She's somebody I personally know. I've had personal encounter with her. Both of us used to serve on the Commercial Court Users Committee. And one key thing we would like her to do is to pay attention to access to justice. And access to justice should not be understood only to mean physical access to courtrooms. Yes, she may have to build a lot more courtrooms in addition to what Chief Justice Anin-Yeboah has done. But access to justice must be understood to mean speedy adjudication of cases that are before the courts and that may come before the courts. And this will dovetail into the issue of e-justice, which I believe she's the best person ever to do that because she's been a champion of it and she's been a chairman of the committee implementing the e-justice program.
Interesting. So that's a way to make sure that justice delivery is accessible to a lot of Ghanaians.
Exactly so. And anytime we would urge her or we expect her to do a lot of engagement and consultation with the bar and other stakeholders, anytime practical and critical reforms are to be introduced because we're going to be those involved in the implementation and we are part of the end user. So I think that a lot more engagement and consultation on her part is important. And that is why I started by saying that we expect her to operate an open door policy. We are always available. And since we are major stakeholders in the administration of justice, I think that a lot more consultation will have to be done with us as far as reforms, critical ones, of course, advancing the cause of justice delivery is concerned.
How critical is this, e-justice system to enhancing justice delivery in this country?
Well, to us, to allow for speedy delivery of justice, what it means is that many of the processes that are done manually will be automated. For instance, service. we may get to a stage where WhatsApp may be used to serve, email may be used to serve. We expect a situation where if you ever have a case this morning and for one reason or the other, the judge will not be able to come, you should be able to have an email early enough or a message, some form of a communication early enough for you not to come around. So that on the part of the lawyers, to once that system is there, if a lawyer is handicapped in a way that he may not be able to come to court or do any other thing that is required, then that same system will be activated so that you also communicate to the court. Then it will allow for proper case management and the workload will move smoothly. We will not then be complaining of workload has done this, has done that. It simply put, it will allow for management of the cases and that will enhance justice delivery on time.
What about in terms of the legal education in the country? Any reforms that the GB is looking for her to do to enhance or open up legal education in the country?
I think opening up legal education in the country is a thorny issue, and I don't think that this should be placed at the doorsteps of the judiciary and, for that matter, the General Legal Council. Practically, what I know is happening is about lack of resources.
Hello, Mr. Kuje.
Call President went to catch salt around UPSA for the law village. As we speak now, the project has become stagnant. I believe it's because of the lack of funds. The only way I think we can open up, as you say, I think the system is already open up. People are given the opportunity, just that we lack space to admit more. So if commitments can be made by way of financing, so that more classrooms and lecture theaters are constructed, I believe any other person who has the minimum requirement to pursue a professional law course will be admitted. So it's not about the Chief Justice. I think maybe she will have to do a lot more lobbying at the level of the people who hold the purse of the nation so that they can advance some money for her to have that relief.
Okay, stay on the line for me. We've been joined by the former Deputy Attorney General, Honorable Joseph Benka, to help us out here. Ms. Benka, grateful that you could also join us. We also have Mr. Mahama Ayarega, Honorable Member of Parliament for Boko Central. He's a lawyer himself. He's also with us on the line. Mr. Ayarega, good morning to you, sir.
Yeah, good morning.
And I hope all is well. Well, you are a lawyer. Your side has been calling on the Chief Justice to try and turn around the face of the judiciary in the country. For you, as an individual, as a lawyer, what are your expectations of this Chief Justice as she assumes office?
Thank you. Good morning once again to you and your listeners. The central role of the rule of law in the development of the country cannot be overemphasized. And apart from Parliament, which makes the law, the body that will continue to apply it and interpret it and ensure that rule of law is really respected is the judiciary. I mean, businesses will tell you about how the administration of justice can stall the activities of investors, how litigation around land matters can incentivize people to make investments, how the way that we handle commercial disputes can make it more difficult for businesses, and the extent that businesses are not sure, are not certain, cannot be confident about the sanctity of contracts and how they will be dealt with, they will not invest. And, we will have a lot of people graduate from universities and institutions, and they can't find jobs because investors are just not investing. They are not expanding businesses. They are not taking risks because we don't make it easy for them to take certain risks. And so we must see rule of law as a matter that is integral to economic development and expanding economic opportunities. And so a Chief Justice must understand her role in the context of not just simply administering justice, but then also the broader project of establishing Ghana as a country that is based on the rule of law. So I expect that the Chief Justice will deal with all these issues. I think that earlier speaker has already spoken about the nuts and bolts, and so I will not, bore listeners with repeating all those items, except to say that those are all the issues that we expect to see her try to improve on the performance of the judiciary.
It looks, for some time, anytime the Supreme Court gives a ruling, the side that, the ruling does not favor seem to have a challenge with it. What should the new Chief Justice do to ensure that rulings given by the Apex Court is acceptable by all parties?
Well, I think that the Supreme Court is also the constitutional court. So they have the basic function of being the ordinary appellate court, where a lot of matters start from the lower court and you can appeal to the Court of Appeal and then ultimately to the Supreme Court. I believe that in many of those cases, there's very little contention in terms of the outcome of... Hello? Hello?
Yeah, I'm listening to you, sir.
I'm saying that when it comes to its ordinary appellate jurisdiction, there isn't that much contention. I think that it is in the area of its role as a constitutional court that very often we see controversy around the quality of the outcomes of the decisions of the court. And then, we have on a number of occasions complained about the quality of the reasoning that informs the conclusions of the court. So people must know that the Supreme Court, being a constitutional court, also gives political direction to the country. And in that instance, they must know that they are speaking to the entire population and especially political groups with interest. And if they don't speak in a language and in a manner that convinces those political groups, increasingly their legitimacy will come into question. Remember that the Supreme Court doesn't have its own enforcement apparatus. Its enforcement is largely based on public support and the support of government. Sometimes the decision can go against government, sometimes it can be in favor of government. But the most important thing is that the reasoning that informs the decision must convince the public that the court is right. And so when the public is questioning the quality of the reasoning, it goes to affect the legitimacy of the court. And that is why you see that there's quite some dispute and disagreement in recent times surrounding the work of the Supreme Court. There are a number of landmark cases that many of us, when we analyze them, we just find it difficult to agree with the logic behind the conclusions of the court. And we believe that there's a need for the court to up its game when it comes to these matters.
But how does she do it when it comes down to an individual's interpretation of the ruling of the court?
It would just be an individual's interpretation. At the end of the day, when the court, gives its ruling and it gives the reasoning, there are all of us who will be analyzing the ruling and the reasoning. I mean, yesterday in Parliament, you saw that the approval process was accompanied by some very heated exchanges on the floor. And we just took two issues yesterday, just two issues. One was the conclusion of the court on the use of birth certificate to prove citizenship. And, the minority had issues. And I believe that if you talk to a lot of people, even some judges, behind the scenes will tell you, we didn't think that a good job was done. So the birth certificate is a document that gives some basic information. Your name, your parents' name, your parents' nationality, and etc. And then the Supreme Court tells us that, you cannot use your birth certificate to prove your citizenship. We're not saying that the birth certificate is the certificate of citizenship, but we're saying that there is some vital information there that a citizen can use to prove his or her citizenship, because citizenship is derived from your lineage. So if your mother is a citizen of Ghana and your father is a citizen of Ghana, or one of them is a citizen of Ghana, or your grandparents, you can use that document because it is a document issued by the state. And on that document, there is information relating to the citizenship of your parents. And so for somebody who wants to prove his citizenship, you should be able to present that document as the evidence. We're not saying that, once you just bring that, then you are a Ghanaian. But then it is a document from which proof can be provided of the nationality of your parents, and therefore the nationality that you derive thereby. So when the Supreme Court says, no, you cannot use the document, if you can't, so which other documents can you use? Okay. Because the person who is providing you with a Ghana card is using that document. The person who is providing you with a passport is using that document. And these are also documents that have been accepted as documents that can prove your citizenship. So it is that kind of ruling that becomes so divisive. But you see, it is divisive because it is a matter that is tied to elections. And there are very entrenched interests surrounding that. And so when you do that, you present yourself as taking political sides, and yet your reasoning for taking two sides or that side is so porous. It's just not tenable. So people just feel that, you are just being partisan. And that is the kind of thing that we want the court to move away from. That, look, you don't have to, because it just doesn't, in the opinion of many people, add up. So those are the kind of situations that people will rely on and say the court is taking political side, and yet the argument is not supported. The logic of the argument just doesn't follow.
Let me move to, grateful to you, stay with me. Let me move to Joseph Benka, who is former Deputy Attorney General. Mr. Benka, so you've been listening to your colleague, lawyer, Mahama Yariga. You disagree with him in terms of, what the Supreme Court should do to ensure that their rulings are not taken to be siding with a political leaning?
Well, thanks very much. Good morning to your cherished listeners. Good morning to your good self and to my brother, the Honorable Mama Yariga, my very good brother. You have to, everything that you say will have to be situated within a certain context. First of all, if you look at the argument my brother is making about the birth certificate, and if you listen to the now Chief Justice who has just been confirmed when she was being vetted, she made a very categorical position on that matter. I think that the birth certificate, from what the Supreme Court has actually said, cannot be a conclusive document as to citizenship. It may be just a prima facie evidence that cannot be conclusive. Because in the end, it may be rebuttable. Because remember that there are some people who go for these birth certificates. They may provide some information to the officers who are going to process these documents that are untrue. So if anybody can prove that those pieces of information you provided to get a birth certificate were untrue, and so you are not actually a citizen of Ghana, it means that the death certificate in that particular circumstance impeached. So it cannot be conclusive. That is the reasoning. It cannot be conclusive. But, you see, one thing I think we should be doing in this discourse is that in making a discussion of this particular, we should situate it within the context of the reasoning they provide and criticize the reasoning, but not just make general and categorical statements about these judgments, especially giving them some political coloration. Because when judgments are delivered and they are not in your favor, and you make comments as though you've lost because of your political coloration, then you try to stigmatize the court and stereotype them in a manner that you hand them over to the public for consumption that will not be good for our democracy. So, for example, when recently the two decisions were rendered, rather interestingly, there was wild jubilation by a section of the population. The case on Domelevu, for example, and then also the case that came before the court to pronounce on the president's powers as far as the emergency act that we enacted in Parliament was concerned. Those two, the Supreme Court declared them as unconstitutional. The people who, architects or the plaintiffs who went to court and the lawyers, the civil society organizations and etc., celebrated the Supreme Court. Now, anytime they render a decision against a certain section of the population or a certain group of people, then you find that the people try to read meanings into the decision as though the court did it out of malice and without reason. And remember that the court is bound by law to give reasoned decisions for whatever position it takes. So all the decisions that are being criticized by people, there are reasons that the court gave for arriving at what it did. It didn't just arrive at that overnight and out of the blue and out of nothing. It indeed did so by following a certain procedure. And in fact, if you read the cases carefully, they normally would, and we are not going to go deep into law now, they normally would give you the cases that they are going to rely on by their own decisions, and sometimes they go out of the country. In this particular case, they cited some American authorities, which are persuasive authority and etc., and then they arrived at their conclusions and rendered a decision. When I heard people criticize that, for example, the equation decision of the Supreme Court, and say that the court should have applied MUPA or modern purposive approach to interpretation and read the provision to mean that it is at the time that you are filing, but not at the time you are filling the form. That is what the argument of critics of the decision are actually saying. But when you flip it, the other fundamental thing is I have contested elections on 2 occasions. When you are going to contest, you take the form from the Electoral Commission. You are supposed to make some declarations, and the declarations are supposed to be signed by a commissioner for oaths or a magistrate. Now, I go to state that I don't owe allegiance to any other country, and then the commissioner for oaths signs. What's the implication? It tells me that at that date that I'm making that declaration, I am convicted without any shred of doubt that I don't owe allegiance to any other country. So if at that date that I make the declaration on the form which is signed and commissioned by the Commissioner for Oaths, I owe allegiance to another country, the Supreme Court says at that particular moment, because of the declaration I made, which at that moment I did not, I owed allegiance to another country or had citizenship of another country, then I was not qualified to contest. That's the reasoning the Supreme Court gave.
So on that score,
they have gone ahead to say that it should have applied to when the filing was done and not the form was. But the form itself, what is on it? So if we think as a people that is wrong, then we fashion out our systems in a manner that will accommodate for it going forward. But until that is done, that is currently the situation. That
Okay.
you make the declaration at the time you are filling the form, not at the time of the election. So that's urging them to make that pronouncement that they should have applied the forceful approach and said that at the time of filing, but not filling the form. Then what's the effect of the content on the form?
You have served as a deputy attorney general before. What do you look up to this Chief Justice to do in enhancing justice delivery in this country?
Thank you very much. And in that regard, I will say that some of the issues that Honorable Mama Yarika said, I will agree with him. You know, the Chief Justice performs a dual role. The dual role as a judge and then as an administrator. So she is, so to speak, the overall chief administrator of the judiciary and provides leadership and direction. And remember that he's the only person who is a member of all the courts. So the Chief Justice can sit as a magistrate, can sit as a circuit court judge, can sit as a high court judge, can sit as a court of appeal judge, and can sit as a Supreme Court judge. And when sitting, of course, she provides the judicial rule at that particular moment. And while performing her role in her office as Chief Justice to oversee, supervise, and take charge of the judiciary, then she's performing the administrative role. So two things will have to happen. You have to manage the two in a manner that will ensure that some of the doubts and criticisms, which are well-intentioned, are actually corrected going forward. For example, I was a member of the General Legal Council for 4 years. And of course, you bring issues about legal education, which is so dear to my heart, because I come from a very underprivileged background. And probably, as I have always said and repeatedly said, if at the time I went to the law school, if circumstances were as they are now, I'm not too sure whether I would have been there. So I think that the idea of opening up legal education should be one of the things that she should leave as a legacy when she leaves office. And she has to fashion out a system that will accommodate the many numbers that are coming out and without compromising quality. You know, and that is why I have subscribed to the argument by somebody like Professor Kwekwaza, who says that, look, liberalize it like it has happened with the accounting institutions and etc. And make sure that you supervise.
Okay.
Make sure that at the end of the day, all those who have LLC have an opportunity to do the deal. And you would then regulate and make sure the standards are not compromised. But because of space, you go and 3,500 people go to write the exam and 500 people are picked. And that pass mark is just basically because of space. We can give all the reasons and explanations. The fundamental reason is because of space. And so if we are unable to have enough space, we should liberalize it, allow the faculty, strengthen them, and supervise, as we used to do when I was a member. And then make sure that, standards are raised at that particular level in the LLB. So I think that in legal education, that's what she could do. And then also, when you look at the judgments, as rightly pointed out by the Honorable Mama Yarika, if investors are not having confidence in the court, nobody will come and put the money here because you can go with a simple matter, liquidated demand, and then it takes you years to be able to get judgment and all that. That would be most unfortunate. Nobody will try. So that we have to also look at expedition of trials, but without compromising quality and decision.
Okay.
Because justice delayed, as they say, is justice denied, but also justice rushed is justice buried. So we make, a balance of the two and ensure that we give confidence to the population that when you are here and then your rights are infringed upon, your rights will be protected by the court expeditiously. Okay,
all right. Grateful to you. Let me turn to Xavier Kwaku Kuje now. Mr. Kuje, so just about wrapping up from your end in the next minute for me, what would be your concluding remarks as we wrap up this discussion, especially when she is about taking office?
Remarks would be that she must show leadership, and leadership means doing more than just occupying a position of authority. I say this because at every level of our leadership in this country, we assume everybody who occupies a position of authority is a leader. That is not so. You can occupy a position of authority, yet you are not a leader. So I expect her to do a lot more. And then my last comment will be on the delay in that the commercial, as far as commercial adjudication is concerned. She's one person I believe will be able to do something about it, because if you remember, I mentioned that I serve with her on the Commercial Court Users Committee. All we're trying to do is reduce the time at which judgment or rulings are made at the Commercial Court, especially when it comes to execution of those judgments as far as business people are concerned. So I wish her well, and I know and I trust she will be a wonderful leader as far as the judicial service is concerned. Thank you.
All right, Mr. Kuje, I'm grateful to you. So Sabia Kwaku Kuje is Public Relations Officer for the Ghana Bar Association. I'm still on.